Can there be an extra tax leveled upon a constitutional right spelled out in the Bill of Rights? That's a question central to a case that's been kind of bounced around in different challenges all throughout the past few years in Illinois when it comes to Cook County and an ordinance they have to charge a $25 tax on the purchase of a firearm and between a penny and a nickel per cartridge of ammunition tax. It's been challenged to the Illinois Supreme Court several times, but the most recent challenge coming from Todd Vandermyde. We'll delve into some of the oral arguments that were heard in the 1st District Appellate Court, 2nd District, 2nd Division, rather. So that happened earlier this week, and they did post audio of that, so that is now available. And I'll have to connect with Todd to get his thoughts on this, but obviously you can find him at Freedom's Steel on YouTube. This is Bishop on Air, where I broadcast each and every weekday morning, breaking down things. We segment out the various clips of different things we talk about, so hopefully you like, subscribe, and hit that notification bell to get those regular updates, especially as my full-time gig has me at the Illinois State House tracking down a lot of things that are moving through, and there's always bills floating around that deal with firearms that people highlight. Everything from, increased budgets for Illinois State Police to deal with revocation, measures to serialize ammunition, putting little serial numbers on each piece of ammunition, and a whole host of other things as well at the Illinois State House, including, enhancing red flag laws and saying that you have to, give your firearms to police if you have a suspended firearm owner identification card. These are all, of course, proposed bills, but when a bill does ultimately cross the finish line and becomes law, it's opened up to the possibility of lawsuits. We saw that with the Protect Illinois Communities Act, which we've got the Southern District of Illinois federal courts still dealing with that. We reviewed in that challenge of the state's gun and magazine ban the Fifth Amendment argument response from the states. So that's also interesting. You can see those videos again. Just look up Bishop on Air and you'll be able to check out the playlist. But ultimately, what we have here we're going to review is a challenge of a 2012 ordinance in Cook County that allows for taxing the purchase of firearms at $25 a pop, and then between a penny and a nickel per cartridge of ammunition tax. And this was challenged multiple times, even Gun Save Life having challenges against this. And it bounced back and forth in the Illinois Supreme Court, and kind of really do need a law license to understand the different complexities of all of this. But we do have audio of the 1st District Appellate Court 2nd Division oral arguments that took place earlier this week, and I do want to air some of that for you. But again, the case is Todd Vandermyde versus Cook County, and here's the plaintiff's attorney.
Kate Hardiman for plaintiffs' appellants. At its core, this case is not about firearms. Rather, this case is about whether governments can single out and discriminate against certain constitutional rights for special taxation. When faced with that question, the United States Supreme Court and the Illinois Supreme Court have repeatedly held that the answer is no. To take just a few examples, the Supreme Court struck down a $1.50 poll tax in Harper and a 4% tax on paper and ink used by a newspaper in Minneapolis, Star Tribune. The Illinois Supreme Court similarly struck down a $10 tax on marriage licenses in Boynton. The teaching of all of these precedents is that no constitutional right can be singled out for special taxation. This principle must apply equally to the Second Amendment, and it renders Cook County's firearm and ammunition taxes invalid. Plaintiffs prevail for a simple reason on appeal. The basis for the lower court's opinion is no longer good law. This court's decision in Gun Save Life 1 has been abrogated in relevant part twice over, first by the Illinois Supreme Court in Gun Save Life 2 and by the U.S. Supreme Court in Bruin.
So again, you get into a lot of the complexity of these different cases. So the plaintiffs laying out there some of their constitutional arguments, but also they boil down just the simple meaning of words like shall not be infringed.
Most of the debate between the parties is about the meaning of the word infringe. And we have cited to you two founding era dictionaries, as well as decisions from two federal appellate court of appeals that hold that infringe means not, as the county argues, to destroy, but rather to hinder. So any tax hinders the exercise of here Second Amendment rights because it makes that right more expensive to exercise.
And then the plaintiff's attorney goes on to address some of the county's defense in continuing forward with this tax.
The county invokes the Tax Injunction Act, but that plainly on its face only applies to restrain federal courts from interfering with state taxation systems. It leaves a remedy in state court, and obviously we are proceeding in front of you in state court. Lastly, the county argues that the Supreme Court's fee jurisprudence supports their position, not the county, not plaintiffs. However, those cases that the county cites all support plaintiffs. This is because they only hold that fees that go to defraying the cost of a licensing scheme are permissible. Now, two problems with that here. We don't have a fee, we have a tax. The Illinois Supreme Court held in paragraph 5 of Gun Save Life 2 that this is plainly a tax levied under the county's taxing authority. And also, the proceeds here are not going to defraying any administrative costs with the scheme. This is a revenue-raising tax that is going into to fund the county's objectives. So those precedents, to the extent that they're even applicable, support plaintiff's position.
So she finishes up her arguments for the plaintiffs in the appellate courts, challenging this idea of taxing ammunition and firearms in Cook County. And then it was time for Cook County's attorneys to address the courts.
Thank you. May it please the court. My name is Jessica Wasserman, and I represent the Cook County defendants.
And she goes on to talk about the previous precedents that they're using and the previous court cases that there have been about this challenge to the Cook County ammo and gun tax that they added on.
The Gun Save Life 1 court's Second Amendment analysis is entirely consistent with Bruin. There, the court explained that its analysis involved a textual and historical inquiry to determine whether the conduct was understood to be within the scope of the right at the time of ratification. This is verbatim what Bruin requires. Further, in determining whether the ordinance fell within the scope of the Second Amendment, the Gun Save Life 1 court held that the challenge taxes do not restrict the ownership of firearms or ammunition. And in support of that holding, the court noted that the taxes weren't prohibitive or exclusionary. This is entirely consistent with Bruin's blessing of shall-issue regimes. They noted that those kinds of regimes are presumptively constitutional while recognizing that if they involved exorbitant fees or lengthy waiting times such that it had the effect of prohibiting someone's ability to keep and bear arms, then that might open up to a constitutional challenge. And further, that analysis in Bruin, from Bruin's footnote 9, this court has already held that that is part of the plain text analysis. In People v. Gun, this court, relying on Bruin, concluded that it didn't need to engage in a historical analysis because an $150 fee wasn't exorbitant. And the same is true here, and plaintiffs have done nothing to distinguish Gun from this case. Gun Save Life 2 in the Illinois Appellate Court also didn't overturn the Second Amendment analysis in Gun Save Life 1. In fact, the Illinois Supreme Court in Gun Save Life 2 explicitly stated that it didn't need to consider the federal constitutional claims. Moreover, the plaintiffs in that case actually asked the Illinois Supreme Court for a petition for rehearing on the Second Amendment issue, which the court denied. So the court made explicitly clear that it didn't wish to speak on the Second Amendment issue. And even if that weren't enough, the Supreme Court, the Illinois Supreme Court's recent decision in Calkins versus Pritzker, offers further guidance that not everything that burdens the Second Amendment necessarily implicates the plain text. The Calkins court explicitly held that a Second Amendment claim was waived, in part because equal protection and the Second Amendment are analyzed under different standards. And in support of that, the court, relying on Bruin, explained that plaintiffs needed to establish that regulated items fell within the category of bearable arms that are commonly used for self-defense today. In their reply brief, plaintiffs tried to discount Calkins entirely simply because it dealt with waiver, but they overlooked that those substantive holdings were integral to the waiver analysis, and as such, they bind this court in its decision today.
So again, you get a mix of different types of, court cases they're reviewing, saying this backs up their arguments, and they even dipped into the Illinois Supreme Court argument. But they discussed some of the plaintiffs' arguments. Here again is the Cook County lawyer defending the county's tax on firearms and ammunition in a constitutional challenge.
Plaintiffs here haven't pleaded that the ordinance affected their conduct at all, let alone infringed upon it. Their assertion that anything that even touches on the Second Amendment is presumptively an infringement is simply inconsistent with Supreme Court case law. For instance, as I've mentioned, the Supreme Court's shall issue discussion in Bruin has provided clear guidance that an infringement requires more than a simple processing delay, firearms training, or the imposition of some kind of administrative fee. Similarly, Heller made clear that laws imposing conditions and qualifications on the commercial sale of arms were presumptively constitutional.
And then the attorney goes on to talk about how they believe that different rights have the possibility of different restrictions on them.
Further, the Supreme Court has consistently held that the First and Second Amendment are subject to different kinds of restrictions. For instance, whereas the Supreme Court has consistently held things like prior restraints are presumptively unconstitutional in the First Amendment context, Bruin and Heller have made clear that prior restraints, background checks, things like that are presumptively constitutional in the Second Amendment context.
So clearly there's going to be a lot of legalese that they debate, and even at some point some of the, and this seems to have been a panel of judges on this case, but some of the judges started going back and forth asking about previous cases that the county was pointing as part of boosting their defense, and here's how that sounded.
I'm not sure why I understand this Williams case you're citing. Recall the facts and tell us why.
Here's the difference, I think, and I wanted to ask
again, these are justices talking over each other.
Part of the case is left intact. For example, don't we have a different case if the Supreme Court in Gun Saves Lives 2 had said, we agree with the Second Amendment finding of the appellate court, but we find that the uniformity, therefore we reverse, then they would be bound by it. But here, they said, we're not going to even consider the second. It was reversed in whole. Yeah. Reversed. And the distinction is a reversed case is different from a case that's reversed in part. Isn't that true?
Yes, Judge. And, similar to what you said, the fact that's important here is that nothing was done to disturb that Second Amendment analysis. So while it might not retain the same precedential value, nothing's been done.
It doesn't have any value. I mean, it's just,
the court said
rendered.
Court said it did not need to reach the Second Amendment argument because the statute was unconstitutional under the uniformity clause. And there was no reason for the court to reach a federal constitutional issue when it had already found under the state constitutional clause that this law was unconstitutional. So I don't know that there's anything left, and I'm not sure I understand your argument still.
So what's interesting here is the trajectory of this case. And if you look at the filing that is initial to this, that's floating around on some gun rights advocate websites, you can see that plaintiffs bring the suit against Cook County, gives background about the Cook County tax, and talks about how they enacted an ordinance to try to address previous court rulings. And then, 2021, the Illinois Supreme Court declared both firearm ordinance and ammunition ordinance, as they read at the time, unconstitutional on the grounds they violated a particular article of the state constitution. As a result, defendants collected and retained the tax from plaintiffs and class members to which they were not entitled. Then in November of 2021, Cook County enacted another ordinance which amended the ordinance further to make it part of taxes for special purpose equity fund. So clearly, the way this played out is fascinating. And if you want a spreadsheet or a flow chart of sorts, you got to kind of just this case alone and all of the different intricacies of it. But back to the plaintiffs with their rebuttal during the appellate court hearing this week on the case Vandermyde versus Cook County.
Also on Calkins, which is from the Illinois Supreme Court, It's important to note that in that case, plaintiffs expressly disclaim a Second Amendment claim. So that case stands only for the proposition that there may be no burden on Second Amendment rights when plaintiffs do not argue that there is a burden. It does not support the county's position here.
So the attorney for the plaintiffs essentially pushing back on the county defense, using the Calkins case to bolster their claims. But the plaintiffs back at it. In final comments here, they address the idea of a general sales tax versus a kind of specialty tax here.
The county argues that this tax is akin to a sales tax. That is just plainly not true. Plaintiffs would not challenge a generally applicable sales tax. Here we have a tax that singles out a constitutional right for special taxation. And therefore, the precedents of Harper and Minneapolis Star Tribune are directly on point. The principle, even though they were in different constitutional contexts, is the same. Constitutional rights cannot be singled out for special taxation. If that is the case for First Amendment rights, it must be the case for Second Amendment rights. After all, the power to tax is the power to destroy, as Chief Justice Marshall once recognized. It opens Pandora's box for this court to allow government to single out a constitutional right it disfavors for special taxation. If this tax is okay, the right to counsel can be taxed. The right to any other constitutional right that this court favors could be taxed as well.
So there you go.
To reverse the judgment below and remand for further proceedings.
That is the final words there of this appellate court hearing of a challenge against Cook County's ammo and firearms tax. And we'll track that and connect with Todd Vandermyde at some point and get his thoughts on how that transpired and what the possible outcomes could be. So appreciate you guys taking the time with us each and every morning. Be sure to like, subscribe, and hit that notification bell. It is Bishop on Air. Follow us anywhere with Bishop on Air.